Good afternoon, and thank you for joining us today for today's webinar. I want to just quickly introduce the people that we have here today. If we could pull up our slide deck. I'm Dona Fraser, Senior Vice President of Privacy Initiatives here at BBB National Programs. And today I'm joined by Katy Ruckle, who is a State Chief Privacy Officer of Washington State, as well as, and she and I will have a fireside chat so that we can kind of lay the groundwork for the panel conversation that will be led by my colleague Divya and her co-panelists. We can go to the next slide. Will be Andrew Barnhill and Simonne. Brousseau. I hope I'm pronouncing that correctly. I've been practicing, but I hope I got it right. So I just want to give a little bit of information before Katy and I have our conversation just about the office in Washington State. So I think it's really important to kind of set the stage a little bit here as to how transformative and how groundbreaking I think what Washington State is doing. The State Office of Privacy and Data Protection was created in 2016. Katy, correct me if I'm wrong there. And the office, overseen by Katy, the Chief Privacy Officer, serves really as a central point of contact for state agencies on policy matters involving data privacy and data protection, and as a resource for consumer privacy issues. I have to imagine that this is rather groundbreaking. Other states are not doing this just yet, but hopefully I think what Washington is doing will be a guiding light for other states, as well as possibly where we land on a federal privacy bill in the future. I'm not going to say near future anymore. I'll say future. So Katy, thank you so much for joining us today. Greatly appreciated.
Thank you. It's great to be here.
Thanks. So as I said, your office has taken charge to really transform the consumer health, privacy, legal landscape as we know it. Last year's My Health, My Data Act will take effect in a month's time, and it has really important implications for healthcare companies, as well as companies that are processing consumer health data for a variety of purposes, whether it's advertising, developing product, data analytics. We'll do a deeper dive, but I would ask that if there's, you kind of walk through, kind of give the audience an overview of My Health, My Data Act.
Sure. So the My Health, My Data Act was created and was Attorney General Office request legislation last session to essentially bridge the gap between how health data is protected by HIPAA and those types of sectoral healthcare laws, and how health data is used in the private sector. And it was specifically really came out of the Roe v. Wade Dobbs decision, which overturned part of the protections for health information for reproductive health care under the Roe v. Wade from previously. So
great. We go to the next. Go ahead. Okay. Sorry. Go ahead. No, go ahead.
Oh, I was just going to talk about the fact that it is a very broad law in terms of consumer health data. And the definition of consumer health data is very broad, which I think gets to some of the groundbreaking efforts that I think you mentioned. And then it is actually one of the few privacy laws that provides for a private right of action for enforcement by individuals versus just the Attorney General's office enforcement actions.
Oh, great. That's real. I think that's very helpful. So we know that you've kind of updated the guidance to clarify about covered entities, right? And that they must post links to separate and distinct consumer health privacy policies on their homepages. Policies can't be merged with another entity's privacy policy. And I think I'm quoting here, it may not contain additional information not required under the My Health, My Data Act. So this is placing additional obligations on companies to do something. So my first question to you is, what are some of the ways that consumers can be more vigilant about how their sensitive health data is being used and processed?
So from the privacy advocacy perspective, and I think from the state's perspective, we would like to see less burden on consumers in terms of having to understand all of the privacy policies that companies have and how understanding how their data is handled. But consumers can be more vigilant, I think, in terms of sharing only sensitive data that's needed for the particular app or service that they're getting. So limiting to the only what's necessary, essentially. And then also they can exercise their rights under My Health, My Data by not signing an authorization to sell their data or requesting to have their data deleted. And then parts of that too are just being aware of if you're no longer using an app, to delete the app from your devices so that it no longer collects data on you unnecessarily. And then, of course, we also just encourage the traditional things that we talk about in terms of protecting your data beyond the healthcare data, which includes things like, strong passwords and passphrases, multi-factor authentication, not clicking on suspicious links from texts or emails, and then regularly updating your software and patching software updates and devices for vulnerabilities.
So when you're making updates to such guidance, how does this process start? Is it, you have the act and it's been passed. When you're doing guidance, are you talking to industry? Are you talking to consumer groups? Who are you talking to develop the guidance?
So my office is not part of the Attorney General's office, so we're separate. And so the focus of my office is typically more on the state agency side and the public sector side, which is less impacted by this law. But we do have a consumer responsibility as well. And so if consumers reach out to us, we try and help them navigate their rights. And a lot of times we're working with the Consumer Protection Division of the Attorney General's office, and we'd be directing them there as well. And then as a part of the bill as well, it's required to create a report based on input and complaints and basically trying to monitor the trends that are occurring to then be able to update guidance based on what's happening. So the law's not quite in effect yet. The geo-fencing provisions are, which I think we're going to talk about in a little bit. But the other main parts of the law regarding the consumer rights and the data handling processes goes into effect next month, and then for small businesses in June.
Great. So in the last several months, and even in the last couple of years, even data brokers themselves have been in the headlines, and most recently, the FTC had a case with Xmode and OutLogic with regards to their misuse of consumers' sensitive data. So obviously, the way that they operate is extremely important. So can you go into a little bit of detail of how the My Health, My Data Act deals with data brokers specifically?
So the Xmode OutLogic case from FTC specifically dealt with the selling of sensitive location data that can be linked to individuals, and that can apply in My Health, My Data, which has a fairly broad definition of what consumer health data is. So, and consumer health data can include specific location data where an individual receives healthcare or even attempts to acquire healthcare or get healthcare supplies. And so, as such, I think data brokers need to be very careful to ensure that the consumer rights that come along with My Health, My Data are followed if they are brokering data that falls within the consumer healthcare data definition. So part of the challenge then for data brokers is going to be requiring the signed authorization to sell the consumer health data, because most of the time data brokers do not have direct relationships with consumers. And so that piece of it will be important to pay attention to make sure they're following the provisions there. I would say that the Attorney General's office did offer guidance in terms of just buying toiletries, not necessarily equating to consumer health data, which I think was some of the speculation initially. So if you're tracking and selling data regarding just basic toiletries. I think they listed things like mouthwash or toilet paper or deodorant. Those types of things doesn't necessarily equal consumer health data. But if brokers are linking that to individuals and making inferences about their health based on that and selling that data, that could bring them subject to the law and the consumer rights that come with that.
So if a data broker is engaged in this practice on behalf of a first party entity, what does that look like for the first party if their data broker gets it wrong?
So the piece to be careful about here is there is a per se violation of the act is a violation of the Consumer Protection Act in Washington that could subject you to Attorney General enforcement or even a private right of action. So that's where you need to be careful.
Right. So that's, I think, important for companies to understand. So I want to move on to the topic that everyone's talking about these days, which is AI. And here specifically biometrics and AI, obviously another important area of interest for regulators, I think both on a state and federal level, obviously. States are taking a very varied approach, I think, on how to treat the definition of biometrics data, whether it's used for identification purposes or some other purpose. So how do you think biometrics and AI are impacted by the Washington Act?
So My Health, My Data, again, has a very broad definition of biometric data, which falls into the consumer health data definition. And so I think that could be very impactful for AI-driven tools, especially if you're using biometric data to train foundational models for generative AI. And so companies in this commercial space need to tread carefully given those requirements. And some of the examples I would give are that since consumers have the right to delete their data, there needs to be a way when you're thinking about developing these models and how you're going to accomplish that to be able to think about how developers are creating the AI-driven tools and then how you can get that data out of those tools if a consumer requests that.
So in your personal opinion, do you think the law is written in such a nimble way that no matter the direction technology goes in, we won't have to be constantly making updates to this? Do you think it's written in such a way that it's nimble with regards to advancement in technology, AI or otherwise?
Well, the definitions are fairly broad, and so
Right.
in that way, it's all encompassing. So laws aren't normally nimble, but in that
Right.
way, it's flexible, right? In terms of having be, I think for companies to be cognizant of how broad the definitions are, especially when linking to specific individuals.
Right. Right. So how does My Health, My Data bills need to be kind of clarified with the boundaries and the scope of HIPAA, right? Which is this sectoral health privacy law when it's focused on patient and clinical records. So where are those guardrails? Where are the beginning and end of that?
So My Health, My Data is clear that it's intended to be a gap and not overcome the definition, I would say, of what protected health information is under HIPAA. So if you are a covered entity, then and you're following HIPAA, you're not necessarily subject to My Health, My Data. But I would caution that a lot of entities are hybrid entities where they may be a covered entity in one space, but they are consumer health. It may fall under a consumer health service in another space. And so just because you are a covered entity doesn't mean that you may not be subject to My Health, My Data. So you need to be cognizant of which laws apply to which lines of business. And there are other several carve-outs within the law as well in terms of if it's health information known as patient information under 42 CFR Part 2, which is the substance use disorder law, which is another federal law, or if it's human subject research, which is common under the common rule or institutional review boards. Those are all sort of exempted out from the consumer health data space and definition and My Health, My Data. And then there's also other various laws in Washington, like the Healthcare Information Act and a lot of quality quality laws that go to quality assurance in healthcare that are exempted from the law.
Right. So I don't know, with everything that's on your plate, I don't know if you've had time to pay attention to what's happening across other states with regards to possible amendments that we're seeing to the definition of biometric data. So I just want to pull back a little bit to biometrics and AI again with regards to the impacts of the way that biometric data in healthcare is processed, or that the health data is used for AI applications. So what are your thoughts on that?
So I think some of the areas we were thinking about in terms of examples was digital health IDs, and I think those being used, and we're even looking at those possibly in Washington as well, as long as they're being processed by insurance or other covered entities under HIPAA, I wouldn't expect there to be an impact. But I think, again, if it's identifiable and meets the definition of consumer health data, then complying with the requirements of My Health, My Data may not be possible to really reconcile with some of the training of AI applications with those other types of biometric data. And then I would really go back to what I was talking about earlier in terms of the considerations for
Right.
the broad definition, right, for biometric data and being able to delete that information out of foundational models.
Right, right. So earlier you mentioned geofencing. So what considerations can you share with companies and consumers about the need to be more deliberate about the geofencing provisions in the law? And then I'll
So
follow up.
the geofencing provisions actually prohibit the use of geofencing at healthcare facilities. And that means they can't be used to identify or track consumers or send messages to them in healthcare facilities. And that can, in fact, sometimes impact, I've heard about potential building security notifications, or it really was intended to I think, address push notifications or targeted ads that were sent. There were some use cases in terms of women being targeted in reproductive health clinics. And so that's really what the geofencing prohibition was meant to get at. But there is some speculation that the healthcare facility definition is so broad, it might include things like gyms or pharmacies or those types of places. And so we haven't seen any enforcement or test cases yet in those things. But I would say that it was really intended to get at tracking or targeting individuals in reproductive health clinics or other sensitive healthcare facilities where we've already seen that data used to target individuals. And so that's what those provisions were meant to address in the law.
Mm-hmm. So, but before I pivot to the panel conversation, I think people who are tuning into this webinar would be curious to know, how can your office, or what is your office doing to help companies, if anything, right? I mean, can companies reach out to you all with questions for guidance? Should that be the AG's office? What is the process for companies who are, it's probably for the smaller to medium size as well, who are kind of struggling with this?
Right. So we're not really built for necessarily company advice or legal advice, but I definitely would welcome getting questions to sort of understand the types of things that are on their minds to help possibly work with the Attorney General's office to get more guidance out to businesses. We're definitely sympathetic to the new regulation and the impacts that it will have. But part of it too is, looking at being responsible with consumer health data and thinking about impacts to privacy.
Do you think, this is my last question before we pivot to the panel, do you think that a co-regulatory model, or what we at BBB National Programs refer to kind of as soft law regulatory model, is something that could work in this space? Would it be helpful? I know we've had conversations with you all and with the AG's office about this. And as states begin to really figure this out, and again, we don't have a federal data privacy bill that would address this, is that something that would be helpful to Washington State?
I think having that type of model would be helpful to be able to provide resources to everyone, because my perspective is that most people are trying to do the right thing and want to
Right,
comply. And so whatever we can do to help ensure their success, right? And then also foster good business and economics is all part of what we want for the
right,
state.
right. Exactly, exactly. So I know you're going to stay on. We're looking at. I encourage the audience to ask questions. We will tee up questions at the end. So please, Katy, stay with us. But thank you so much for kind of setting the groundwork for the panel conversation and explaining the law, the regulation, and what's to come. So thank you so much for your time.
Thanks for
Yeah,
having me.
And I'm going to
thank
turn
you.
it over to Divya now.
Awesome. And thank you so much for Donna and Katy for such an insightful discussion. I think I learned a lot. You were able to go both deep and wide at the same time and kind of get into some of the nitty gritty on certain aspects. So thanks again for that. And I think you all touched on a number of interesting key considerations focused on everybody's favorite subject right now, AI. So we will dig into that, but let me do a quick intro. I'm Dr. Divya Sridhar, here Vice President for Global Privacy Division, and I have with me my colleagues Andrew Barnhill, who heads up legal and global legal policy for IQVIA, as well as Simonne Brousseau, who's an associate at Faegre Draker. I'm going to share my screen, and just give me a second for that transition, and then we will get into some interesting questions. So this is you all are going to get, as part of the audience, you all will receive a copy of our deck. I know Donna mentioned that, but just know that they covered a couple of these important topics. And I think it's helpful to set the stage for our discussion about the practical business considerations. So first question, Andrew, as it stands, the industry gets a bad rep about the lack of guardrails on how AI in the healthcare context could further amplify the negative consequences on how sensitive health data is processed, shared, and sold. The World Health Organization actually just published a report on AI in healthcare. We'll include that in the resources. It's a really meaty 150-page report. I have it here on my desk. It's awesome. So folks should definitely take a look at that. And I'd love to look to you, Andrew, to get a better sense of what are some of the positive use cases of AI, across your company that you've seen, across the years that you could shed light on, and how has that reflected innovation in the space?
Sure. Well, first, thank you, Divya, so much for having me, and all of you at BBB National Programs really have appreciated the opportunity to dive into some of these key issues that we're focused on the regulatory and the legislative end. So I have the pleasure of leading public policy for IQVIA, which is the world's largest clinical research and healthcare data company. And we've had a chance to take a look into the impact of AI for many years. One of the things that we sort of chuckle about in our company and in the industry is that in some ways people are just coming to understand AI and ML, but many of our scientists and our clinical leaders and our data experts have been working in the AI space for really 2 decades now. And so we've had a chance to explore what works, what doesn't work, and what some of the exciting applications actually are. One of the first things that we try to explain is the rich history of AI inside the life sciences and the positive impact that it's having in both the clinical and the population health sectors. And it's doing a number of things, whether that's improving patient healthcare outcomes, whether it's connecting patients to social programs, reducing clinical burdens, optimizing resource allocation in particular areas of healthcare delivery, reducing healthcare cost, or aligning to clinical guidelines. Those are just a few of the categories where we're starting to see over time the positive impact of AI. One of the great case studies that we have to offer, and we actually have a series of case studies in what we call AI for Good, has been in the instance of predicting the risk of stroke that actually led to a 22% reduction in stroke incidents inside a particular study. And that's a great example that I think we often like to share because we had a customer that we were working with that was interested in taking a look specifically at what they could do with AFib patients who are 5 times more likely to have a stroke than non-AFib patients. And this provider organization had about 250,000 patients, and they wanted to design a program to improve the care management of that particular population. And so we partnered with them to identify at-risk patients and improve the use of certain types of therapies. And we leveraged some AI through EMR data where we could isolate age, gender, and clinical risk factors. And ultimately, through this process with that partner, the annual number of strokes was actually estimated to fall by 22% during the implementation phase. So that's just one small example with one particular partner, but it's a great instance or a great case study of leveraging AI and ML tools for predictive capabilities with patients directly.
Now that's great. And it sounds like you will be a great example of a company that falls right into that intersection of being a hybrid where, you're impacted by HIPAA and now also the My Health, My Data Act in certain circumstances, but you may also be subject to exemptions based on the public health research use cases. So that's really helpful, and we'll get into that a little bit later in the discussion. Simonne, I want to turn to you for just a second to see if there's any examples you want to shed light on or anything else about the scope of some of these consumer privacy laws that also impact AI that you'd like to jump in on.
Yeah, thank you, Divya. And just would echo Andrew's sentiments as well. Thanks so much for having me. With regard to AI in the life sciences space, we certainly see companies across the industry using AI for various different use cases with respect to clinical trial recruitment and other clinical trial development purposes. And just to note, of course, that AI is such a broad concept that there's really very light regulation at this point, and we're seeing so much national attention to AI, especially the past year, but we're also seeing regulators and legislators still very much figuring out how to regulate these technologies at the same time as industry is figuring out what they can do with these technologies. And then, as we'll talk about, we have all of these new consumer health data regulations that kind of layer on top of that different restrictions with respect to what you can and can't do with data. So very much an interesting time with respect to all of these technologies as they continue to develop.
Awesome, very helpful. So let's dig a little bit deeper into this question of AI in healthcare and the fact that consumers face this burden of lack of trust and added risk with regard to a technology that's been around decades. And I think Andrew's the slide before this where we saw the IQVIA report shows citations from the early 2000s. I'm sure the AI technology has been around even longer than that, but used more fervently more recently. And so the next question is about how do we build more trust in the use of AI? I'll turn to you, Andrew, to give examples of how IQVIA has made efforts to mitigate the trust and safety barriers and the issues associated with AI for consumers. I mean, these can be a range of different repercussions, from error rates to system design issues, side effects for consumers, bias in the systems themselves that can, replicate upon themselves. Could you just share, what you all are doing, what your approach is?
So we've approached with an understanding that trust is pivotal to any relationship or application of AI now and in the future. And so with that in mind, one of the things that we've done as a company is to create a series of guidelines that link to fundamental principles surrounding the use of AI. So I'll speak to those very broadly and then give some examples here. And those are fairness, respect, transparency, and accountability. So fairness being the generalizability and concerns about the risk of accentuating certain inequalities, and so we have a laser-like focus on that. Respect, as in the rights to use data and an individual's privacy. Transparency has everything to do with visibility into decisions, but also data points and then performance. And then finally, accountability. So, how are decisions made credible and how is their use defensible? And so within those categories, we've looked at examples of kind of furthering that relationship of trust with our individual customers that we may be interacting with. So that may be, building what we consider privacy assured green zones for machine learning experimentation, example of the category of respect. Systematic analytics of re-identification of data, through internally developed AI software. That's another example. Publishing an inventory of the peer-reviewed methods in AI so that our customers and clients are aware of what specifically we are doing. Benchmarking, of AI against alternatives, to kind of share its effectiveness and where there may be areas of lower effectiveness. We also have an internal AI council with a robust AI operating model, and actually specifically one for GPT-like tools as well. And then we are, continuously, profiling all of our data for potential biases and, examining how that data is collected and how that may be used. So those are just a few examples, but they all fit into those categories that we've set out to provide some principles around AI use and around fairness, respect, transparency, and accountability.
Sounds like the World Health Organization stole a page out of your playbook, because I looked at the table of contents and it appears that there's a direct alignment in the ethical principles that they've shared, some of the challenges they've shared, and the accountability model that you kind of divvied up there. So that's very helpful to hear about. My next question surrounds, one last question on AI before we get into the meat of consumer privacy, which is my favorite topic, of course. So looking at the regulatory framework in the US, there's this misconception out there that healthcare and AI in healthcare is really an unregulated space. We're now seeing a number of laws that have been added on the books, but with regard to AI, there's really not that much out there. And well, that's the misconception, right? But at the same time, we're seeing the wheels moving, really fast on the EU AI Act in other parts of the country, in other parts of the world. Can you share, Andrew, a bit about kind of the comparison across the regulatory regimes with the EU AI Act and, the FTC regulatory authority here in the US, as well as other, state-specific AI laws that are in place that may be impacting the healthcare sector?
Yeah, I think we're hearing a lot that, Europe is far ahead of the US in terms of regulations and standards in AI use. And in some ways you can make that case. But I think the distinction and why it gets a little bit confusing for those in the US or those who are looking at US policy is that there's not been one large comprehensive AI act in the US at the federal level. So, we've struggled with questions about should there be a federal Privacy Act, same sort of discussions around AI. And Congress is still in early days. So you're seeing committees of jurisdiction start to take on questions about AI transparency, AI accountability, and there are several different working groups focused on the healthcare side of that as well. But beyond what Congress may or may not be doing, HHS has been involved in issuing some guidance surrounding privacy as it relates to AI. The FDA has put out some best practices surrounding AI in clinical trials and in their approvals processes. They've also been involved specifically in some guidance surrounding the use of AI in real-world evidence or related to the generation of real-world evidence. FTC, of course, as you mentioned and talked about earlier, have several actions related to AI. So I don't think there's an absence of it at the federal level. I would just say there's not a comprehensive or united effort at this point. Yes, to your point about states, there are a number of states that started sort of along the journey of creating comprehensive privacy bills without including AI. And interestingly, some of the states where they haven't yet passed comprehensive privacy bills are now thinking, oh, okay, this should also be an AI bill. And we can talk about those a little bit later in the conversation. But hopefully that gives you a sense. Yes, there is a difference in the approach that we're seeing in the EU, but that is not to say that the US is completely out of the picture. It's just a little bit less unified.
Great. Good answer. I thought that was really comprehensive. Let's move into the portion of the discussion that's going to focus on consumer privacy. And here on the slide, and I'm going to take the slide down in just a second so we can kind of just have a more robust conversation. But you can see all of the developments that have happened, particularly with regard to FTC enforcement action and regulation in the space, but also at the state level, as you alluded to, Andrew. Not only have there been, close to 15 state consumer privacy laws added to the books that focus on new definitions for sensitive data. There's also 3 consumer health privacy laws that are, also that have been enacted and that will take effect this year. That's Washington My Health My Data Act, Nevada, and Connecticut. And we've seen some copycat bills this year that have been introduced. And so this slide gives you kind of a sense of everything we're seeing out there, this kind of Hail Mary effort to take action right now on consumer privacy. So let me stop sharing this slide and let's get a little bit deeper. Simonne, I'd love to get your expertise. I know you work with a range of clients across different sectors. Would love to hear from you about, the landscape and how much it's changed as we just saw. Can you comment a bit about what those trends look like, at a high big picture level, as well as maybe at a more narrow, with regard to sensitive data and some of the definitional changes that have happened over the years?
Yeah, absolutely. So as you mentioned, we have 15 or so state comprehensive privacy laws now in the US. These have all popped up in the past 3 or 4 years in the US. And we're seeing, with respect to consumer health data, just an absolute explosion over the past 12 months or so. So with respect to what consumer health data actually is, as Katy discussed in the first half of the session, this is a focus on health information that is not covered by HIPAA. And so we have, historically in the US, we've had HIPAA, which regulates the collection and use of health information by covered entities and their business associates. And then with respect to health information that's not within the scope of HIPAA, we really haven't had all that much in the United States. Just in the past year, we have FTC enforcement actions against GoodRx, BetterHelp, and Premom, all relating to use and disclosure of sensitive information. And this in particular, for each of those enforcement actions, those were relating to information that's being collected via tracking technologies. So this is really regulators cracking down on collection via cookies, pixels, and other kinds of tracking technologies of information that can infer something about someone's health. With respect to GoodRx, it was information about medications they were using based on, for example, somebody going to a website about a coupon, a drug coupon. For the Premom case, it was people putting in ovulation test information into Premom's fertility app, and then that information being sent over to third parties for their own advertising purposes. So that's really what we're seeing regulators cracking down on. And then in relation to that, we're also seeing, of course, the My Health, My Data Act in Washington and the copycat bill in Nevada really focusing on the same issue.
Yeah, and actually that's a good segue. When you think about all the consumer health privacy laws, there's only 3 that have been enacted, but there's so many bills that have been introduced, I think, over the last 2 to 3 years. I think especially after the overturning of Roe v. Wade, the Dobbs decision has really prompted state legislators and regulators to act on these issues, especially to safeguard their constituents' sensitive consumer health data. One question I think we were going to dig into on the state level was how, Andrew, you mentioned the amendments there, how a lot of legislators are coming back in to make additional changes to laws that they've already passed. It might be, Connecticut's a good example of this. They passed SB 3 on the consumer privacy side. I remember digging really deep into that. And then they came back last year with additional amendments focused on minors' data as well as on the health data. And I believe this year they're considering a few more changes on top of that. But are there examples of that you've seen with regard to AI or just in general, some unique ones that you think are worth the attention?
Yeah, I mean, there's a lot of interesting things going on at the state level. The states are always the laboratory for innovation, sometimes for good and sometimes not. But we see a lot of exciting things happening. So to your point, we saw this sort of string of comprehensive privacy bills that developed really 2019, 2020, 2021. And then sort of some of the later ones started to factor in sort of children's privacy, children's data. Then we started to see a string that was focused specifically on AI in particular. So one of the things that I'd like to do is highlight a few of those and kind of touch on what we've seen working well, what we've seen some unique examples and that might interest some of the audience. So as of in the 2023 legislative session, so the last legislative session, although some are 2-year sessions depending on your state, there are at least 25 states as well as Puerto Rico that have introduced AI bills of some type. So that's quite a lot. I mean, basically half of them. And then 17 states from my last count have adopted some sort of resolution or enacted legislation that might in some way touch on AI or data privacy and data security. So a few of those are what Connecticut did recently on top of their original bill. They've required their State Department of Administrative Services to conduct an inventory of all the state systems and state agencies that employ AI starting February 1st, so starting the beginning of this month. Performing also ongoing assessments of the use of AI within the state. And it also requires the state's OPM, their Office of Policy and Management, to establish policies around procurement and implementation surrounding AI. So that's a pretty extensive one, more than what we've seen in a lot of places. Louisiana recently focused on AI as it relates to cybersecurity. So they didn't pass a bill, but they adopted a resolution requesting their Committee on Tech and Cyber to study the impact of AI, specifically in the cyberspace. Maryland did something that was pretty unique in that they established a grant program, what they're calling Industry 4.0 technology program, that will actually assist small and medium-sized businesses in the state to make use of AI. So they're doing something a little bit different, where they are actually encouraging the practices of AI through businesses in their state. So all those are some examples. Two big comprehensive privacy bills, though, that are generating attention are in the states of Michigan and Massachusetts. So those were not AI bills per se, but they have components related to the uses of AI that are worth some review and evaluation. Michigan's has also currently in process to try to shape the use of clinical research in the state and specific provisions surrounding data for clinical research. Massachusetts is looking at the same thing. Massachusetts is also looking to regulate data brokers like some other states are, but is considering AI in theirs. So a number of things happening at the state level, both incentives for the use of AI by businesses, also regulations surrounding the use of AI for government agencies. You name it, we're starting to see it in the states. My impression, though, is what you typically would see, a year or two down the road, you'll start to see a convergence with some of the practices where, a half dozen or so states are recommending specific best practices, and then more states follow suit. This is what tends to happen. In the early years, you see the variety that I've mentioned, and then you start to see things come together a little bit more. Now, will that then become a model for something at the federal level? I don't know, but sometimes that happens as well.
So Andrew, you checked all the boxes with regard to all the states except California. So I'm going to do a quick plug because we do have, California is huge. And I know a lot of states, are startups all the way to some of the largest companies have a presence in California, and CPRA and all the changes happening now with AI and automated decision-making is going to take, I think, the country by storm, and many states may model what California is doing. But I will do a quick plug because our California Privacy Rights Act program, our compliance program, is one that really focuses on some of those nuances with regard to capturing not only what's in the 2023 regulations, but also, focuses on building on some of the proposed changes that are now, likely to take, that are likely to go through the rounds this year with the CPPA, and then, potentially become final. So I think that's another interesting state to kind of keep your eyes on. Simonne, I definitely want to turn to you. I know you all published a very exciting report just today that just came hot off the presses. We will be sharing that in the resources. Please tell us more about kind of the key takeaways around My Health, My Data Act, as well as more about that report that you all put together. I think it might have been a client briefing, or maybe it was broader than that, but please do share.
Yeah, so that goes back to sort of where I started off with my last response, just kind of framing this as thinking about all of the changes in the consumer health space in the past year. So we're seeing those FTC enforcement actions. We're also seeing changes at the legislative and regulatory level. And really right now, we have companies trying to figure out how to navigate all of that so that they can be compliant with FTC requirements. They're compliant with Washington and Nevada coming up in March. And they're simultaneously complying with things like the Colorado Privacy Act requirements, regulations, which have detailed requirements for obtaining consent for collection of sensitive data. So really right now it's companies trying to figure out how to navigate all of these different sources of law with respect to collection of sensitive data, disclosure of that information, consumer health data privacy policies are a requirement under Washington and Nevada law. And then just to note that, of course, this is sort of to Andrew's point a moment ago, this is the beginning of the regulation of the consumer health data space. And so a couple of years ago in the comprehensive privacy legislation space, we saw the CCPA we saw California adopting the first comprehensive privacy legislation in the US, followed on by legislation in Colorado, Virginia, and various other states now that have kind of followed that same model that Colorado and Virginia adopted initially. In the consumer health data space, there is now sort of a question of what we're going to start to see next, and how, as companies adopt language that they can use for consents for sensitive data for their programming, for the cookies on their website, for different kinds of programs that consumers can opt into, how that's going to have to continue to evolve over the next 6 months, 12 months, 18 months, how that's going to be a challenge for businesses in terms of just implementing that and continuing to implement new language over and over. And then just kind of the question mark of like, what states are going to be adopting the next consumer health data laws? What are those going to look like? Are they going to follow the Washington model? Are they going to add new obligations on business? And so that's sort of what we are working with companies on a day-to-day basis.
That's great. And Andrew, if you want to chime in as well, I think, follow-up question to that, are there any blind spots that, you think are really clear for company? Well, the blind spots are unclear for companies and makes it challenging, especially if they're intertwined in many different ways, just like IQVIA is with regard to HIPAA and these consumer privacy laws and just this mess of regulation and law that they have to unpack. Anything you want to share there?
Sure. I don't know that I would necessarily respond specifically to blind spots, but I do think for healthcare companies that are engaged in a lot of avenues of impacting patients' lives, maybe directly and then perhaps indirectly, we're often several steps removed. And one of the big questions for us is, how are our vendors using AI? How about our clients or our customers? We operate, many of us do, in a life sciences ecosystem, and not everyone looks at privacy the same way. Not everyone will employ AI and ML the same way. So I think for us, the question that's most important is, how do we get our definitions right? How do we come to understand the applications, together between each of us that are involved in this ecosystem of trust for patients? And we're going to probably see blind spots along the way, but right now we are all learning, and I think it's important to make sure that we can describe the same things the same way, so that we can get in front of potential challenges as they develop.
Awesome. And one final question for you both before we have Dona and Katy rejoin, and then we can take some questions from the audience. Simonne, I think your recent report, the report that came out today, touches on the practical business considerations. You named a couple of them, but if you were to give companies maybe 3 immediate action steps that they need to take as soon as possible to comply with the My Health, My Data Act and some of these other laws, you name it, could you share kind of where you think companies should look, and what those action steps would be?
Sure. So in terms of figuring out how to structure your consumer health data compliance, at the outset, companies really need to be understanding what they collect in terms of consumer health data. And that starts with an understanding of just what consumer health data is to begin with. So regulators are increasingly taking a very, very broad view of what consumer health data is, really to mean anything that can relate in some way to an identified or identifiable individual that relates to health. And so if you look at the Washington AG's guidance on the Washington My Health, My Data law, there's a mention in there of retailers collecting, for example, non-health information, like people making purchases at purchases at retail stores, and then using that information to develop a pregnancy prediction score. And you can sort of carry that over into any type of health prediction inference that companies might be making. And so regulators are increasingly taking the view that that itself is health information. And that also, as in the GoodRx and BetterHelp cases, just the fact of someone visiting a website that's targeted, that is descriptive of some kind of medication or health condition, plus an identifier like an IP address or a mobile advertising ID, just that fact of that person visiting the website, that being health information that then can't be disclosed to a third party without consent. So really all of this, and companies need to be thinking about what they actually collect and what kinds of consumer health data they have. And then they also need to be thinking about, in conjunction with that, where do they need to place consents for collection of that information now? So in the cookie context, I think we had a question through the chat about just how to pose those consents in some kind of practical way to gain consent for collection and disclosure and sale in the ad tech context. I think that's the big question that we've been thinking through with a lot of companies. This is really, really hard to do, and it's driven by the fact that this is regulators and legislators trying to kind of push companies out of this space and limit the use of sensitive data across the board so that we really are protecting consumer privacy.
No, that's great. And we can turn back to that question. That might be one that, Katy and Dona would like to speak to as well. Before I do that, let me close on one last note, and that will be, and you're going to get a copy of these slides, but just to share, kind of this, the risk reward ratio and how that, with using innovative tools and technology and sensitive health data, and how that is impacted by the broader landscape, especially the consumer's trust in brands and brand recognition. And so, that's exactly what BBB National Program stands for. We believe that accountability can solidify this trust and ensure that companies are meeting the appropriate compliance best practices and standards, and that you feel that your customers, do have that that feeling of safety and like robust accountability from a third party, right? And so just to give you a sense of that, we have, in this deck, a little bit more information about what we do and the privacy compliance standards we follow, as well as our broader global privacy programs. And as I mentioned, our California Consumer Privacy Rights Act program as well, in case that's helpful for companies listening in right now. So I'll stop there. Dona, do you want to jump in on the question? I know Simonne kind of got to it, but I don't believe that we even asked the question. So
right, yeah, sure. So the question that Simonne touched on, and Katy, I'll pose it to you in case you want to chime in on this. The question that was submitted was, please discuss the practical models for obtaining 3-tiered consent for sales of consumer health data under My Health, My Data, especially authorization for ad tech.
Oh, sorry, you're posing that to me. I'm here
Yes,
to answer the
that's
question.
okay. That's okay.
So I have less familiarity on the ad tech side. I'm more familiar with that on the clinical research side. So where there are some carve outs for handling that type of data, I can say that I think that companies should be especially vigilant in getting having a record of those consents and how they're obtaining them to be able to sell the data, because I am under the impression from statements, that the Attorney General has made, that that's going to be an area of particular interest in enforcement. So I would, tread carefully and make sure you have your documentation ready to go.
Right. Great. Thank you. Divya, I don't know if I'm not seeing any. I don't know if I think you said you may have another question, but I'm not.
Let me see if there's anything else. A couple of people asking for the resources, which we will definitely share. Yeah, actually, one quick question, and Simonne and Andrew, you all may be most familiar, able to answer this with brevity. With regard to the health breach notification rule, I know the FTC had a proposed comment underway, and some changes made, kind of surfaced this year with regard to that. I don't know whether you all had commented on it, Andrew, and you want to kind of share a bit, or Simonne, if some of your clients needed some additional, framing around the health breach notification rule and impacts, I think, for sensitive health data. Would love to hear your thoughts.
Simonne, you want to jump on that?
Sure. Yeah, I mean, so the health breach notification rule has been around since 2009. The first time it was enforced was in the GoodRx case, February of last year. And really, when I discussed a few moments ago the evolution of consumer health data laws in the past year, we really saw this start a year prior to that with the FTC's sort of reinterpretation of the health breach notification rule, releasing that in January of 2022 and taking the position that disclosures of health information as defined under the rule to third parties without consent of the consumer constituted a breach of health information under the rule that could be enforced by the FTC. So we saw that interpretation coming in 2022 from the FTC. Subsequently, we saw, of course, Dobbs v. Jackson overruling Roe, and then increased federal and state scrutiny of all of this, combined with sort of general concern about consumer tracking and targeted advertising at the state level in all of our consumer privacy laws. And so certainly the health breach notification rule has been critical to all of this. And we saw in the GoodRx case and also in the Premom case, for the first time ever, claims under the health breach notification rule coming from the FTC. It's going to be, I think, one of the ways the FTC is going to continue to bring these claims in the future, and also as a way for them to leverage their penalty authority because the FTC has limited penalty authority under Section 5 alone. So even though we saw limited monetary penalties under the GoodRx and Premom cases, likely to see further enforcement from the FTC, including under the rule, to the extent they're able to do so.
Yeah, so I guess bottom line, know your consents and know the definition that the FTC has laid out, as well as My Health, My Data. It sounds like that's the common theme, is they're kind of taking another look at that. Awesome. Oh, Donna, I think you're on mute.
Yep, thank you. After all this time, you think I'd know by now. So thanks everybody for your time today. We really appreciate it. It's been extremely informative. Again, for those who have attended, you will receive the deck along with the resources attached to it as well, and the contact information. So please do reach out to us with any questions, or our panelists with any questions. But thank you all so much for your time. Simonne and Andrew and Katy, thank you so much.
Thanks, everyone. Have a good one.
Thank you.